BIA has mandated that there's no bond for people who have come in the United States without papers. Now, this was already happening based on a memo that was sent in July. That was already happening in courtrooms, but each court had its own jurisdiction, its own discretion to say what they thought about whether it was or wasn't fair to follow that rule, because they were saying that basically everyone falls under 235B for mandatory detention, that they're not eligible for bond by a judge because they came in without papers. And they were basically saying that anyone who comes into the country is applying for admission whether or not they had papers. Now, this is basically part of the issue, is that the fact that Trump put in people in the Board of Immigration Appeals. He replaced people who were previously in the Board of Immigration Appeals. So his believers, right, are there at the BIA, and we see that they are enforcing his regulations and his thought processes. So the Board of Immigration Appeals ruled on September 5th that anyone who entered the United States without inspection must face mandatory detention and is ineligible for bond under 235B. And this applies even if their parole was later revoked or if they were previously released. So we have a couple of people who are possibly subject to this rule, and what we're trying to do is actually say that they should not be subject to 235B because they were previously in 240 proceedings, and this client specifically has their case administratively closed. So we hope that we can distinguish the BIA decision from our specific client's case, but it's going to be much harder to get anyone out of detention now if they have come into the country undocumented. Okay, overstays and people who previously had an H-1B or they had an F-1 or they came in with a B-1, B-2 visa, those people are not affected. It's people who came in without status.